Hello and welcome back to Law Torn, the podcast which explores what happens when family rifts turn into courtroom battles. My name's Samara Dutton. I am a partner in the private wealth disputes team, and I'm here with Philippa Dolan, a partner in our family team.
Hello.
We are going to be talking about today common law marriage, which it amazes me is something that people still believe is a real thing and that will give them rights. So I remember when I first came into the law, people thought common law marriage was a thing, but I thought by this time everybody would have realized. I really thought it was a myth that had been debunked by now, but looking at statistics in preparation for our chat today, it seems nearly half the population, 46% or something, still believe that common law marriage is a thing and that people that live together have the same rights as people who are legally married.
Good heavens, I'm surprised it's so high. That's roughly the same percentage of people who live together and don't get married. So does that mean most of them think they've got rights?
Yeah, I think, well, who knows if it's the same 46%, etc. But it's an astounding figure, particularly in these days, given the sort of coverage of these kind of claims that take place between people that, you know, that have fights over assets and properties that are or aren't married, etc. You just would have thought that this message would have made it, because it said, you know, it's been the same percentage for more than a decade.
I wonder if it's partly because people read in the media about wealthy people who are not married and different rules will apply, which we'll come on to. And maybe they see arguments about whether you are entitled to an AstroTurf for your 2-year-old or whatever it was, can't remember the story, and that you're entitled to, £1 million a year. And people then think, oh, right, okay, so I've got rights, but actually you haven't.
It's not the case, is it? So we are going to focus on a sort of scenario because we have had a question sent in about this topic, which is what encouraged us to talk about it this week, which is from a woman who has been with her partner for 10 years. They have 2 children, 7 and 9. She gave up her job, her career, to look after the children. She was a stay-at-home mum. She has been for, I guess, 9 years now. She says that her partner is very keen to marry her, but she is not somebody who's ever really wanted to be married. So it's not something that she's interested in. And in fact, they live in a home which is in his name. And she, rather than, in fact, in opposition to wanting to get married, she's actually considering what her rights would be if their relationship came to an end now, because she is starting to think that the reason she doesn't want to get married is because she doesn't really want to be with him. So is there a way that she can remove him from the picture and keep her house with her children in it?
You mean his house with the children in it? And the answer is almost certainly not.
No, there's nothing at all.
Well, she has no rights. As someone who just lives with someone, you have absolutely no rights. You then have to dig around and see if there are alternatives. The fact they have children is very helpful to her. If they didn't have children, and she wasn't a builder who's, massively increased the value of the property, for example, then she'd have absolutely no rights. The fact they've got children takes it into a different category, which would then bring in something called Schedule 1 of the Children Act, where, assuming the children can spend at least half the time with her, and probably more if she's a stay-at-home mum, then she then is able to say on their behalf, we need a home. And it has to be a suitable home subject to what money is available. So I can see an argument in that case for her being able to say, well, let me stay in this house until the children are grown up. And on that basis, the court might agree to that if depending partly on his circumstances and whether he can go and afford to live somewhere else, and still have a home where he can see the children, because the assumption is they'll both spend time with the children, but probably more with her than with him. So, and then there are other claims you can use if you're the parent living with the children. Um, you have to have quite a lot of money to start saying things like, and I need to send them on a skiing holiday this year, or we need a really good grand piano because one of them's showing signs of being good at music. So, but that's really only in the more wealthy families. So if they're just a normal family, then probably she might be able to stay in the house, which is still his and which he will recover once the children are grown up. It's a sort of enforced investment. But that's about it. Clearly, child maintenance is payable anyway, whether you're married or not married. But she has no actual rights as a cohabitee.
So no interest in the property whatsoever, and no route to having one upheld in her favour based purely on the fact that she's lived there and provided a home for him.
Not at all. Not at all. You'd have to start digging around in trusts and try and erect some argument that, proprietary estoppel or
it was promised.
Like
it was promised to.
Yes.
But so then what is the difference if she's in the same scenario and she's married?
Well, we don't know exactly what he's worth or what they're worth, but the starting point is she'd then get 50% of everything that has been acquired during their relationship. So it makes a huge difference. And if the children are going to be living with her, actually, if the children are going to be living with her, but there's enough money in the house to provide for 2 homes, then the property will probably be sold. If not, there's a very good chance that she would stay in the house again, and probably until the children are grown up, and then they'd split it between them. And other assets, pensions and savings and, a yacht, they're all come into the equation, and she's entitled to half. And sometimes, quite often, if it's not a wealthy family, she might get more than half. And she'd also have a claim for spousal maintenance because she's been at home and not pursued her career. I mean, it's a totally, totally different picture.
So really, we should be advising her to marry him.
Well, it's an unethical approach, but it may be a legally clever one. But yes, if she married him, all the preceding years of cohabitation will automatically then be added on to the length of the marriage. So
what I'm inferring from that, I'm sort of racing ahead in my mind. So even if they're only married for 6 months, it will count as a 10.5 year
they've
relationship.
got a 10.5 year marriage.
What is the minimum period you can be married to someone for? Is there such a thing?
A year.
Oh,
in fact, oddly enough, I've just got a case in where they're not quite a year, but they're going to get divorced the minute they've been married for a year.
But it has to be 1 year to qualify.
Yes.
For that.
Well, you can't get divorced unless you've been married for a year.
Okay.
I mean, maybe exceptional circumstances like, you've been chased around by a serial murderer. But generally speaking, you have to be married for at least a year before you can start divorce proceedings. And then it takes a minimum of 26 weeks and a day before you can finalise the divorce.
And how long does it actually take in process?
Years, probably. No, well, it depends. If you're arguing about money or children, money, then years.
Okay. I mean, do you have a lot of people approaching you for advice on this basis that are not married, but
yes,
what are my rights? What can I do?
Yes, it's a growing proportion of our workload is unmarried couples, which is hardly surprising when you look at the percentage of unmarried couples.
And so then what are the routes that you're suggesting to them other than getting married to someone they don't
Well,
want to marry.
cohabitation agreements, that's one option, or just a trust to deal with the property.
Presumably that takes some forethought. And if you're already in a position where the relationship's at an end, you're not.
Oh, yeah. Well,
I mean,
yes,
these are
exactly.
agreements that will help. They're basically an agreement to say how you hold it and how it will be managed in the event of the deterioration of your relationship,
Yeah.
basically.
So some people are very sensible and grown up, and they do sign cohabitation agreements at the beginning of their period of cohabitation. Most people don't.
Mm.
And of course, the trouble is, like everything, that you only think about what might happen if it goes wrong when there's a little bit of you that's thinking,
It's starting to go wrong.
like this woman where she said in her letter that, he was dull.
Yeah.
And she'd realised he was dull, and the relationship, as far as she was concerned, had sort of run its course. But,
Yeah.
so it's not simple. I mean, unless everyone starts deciding that unmarried couples should have cohabitation agreements, or what has been on the cards for at least 30 years, to my knowledge, the idea that unmarried couples have rights, which is now probably more likely than it's been so far in my career.
But where's the sort of gateway for that? Like how long? What if you move in with a friend and then after a while you become a couple?
I know. I don't know. I mean, they do it in an awful lot of jurisdictions, including Scotland. So,
okay.
But there'll be, I imagine, armloads of case law about what constitutes a cohabiting relationship.
It's the joy of any new kind of rule, isn't it? It's the satellite litigation. Yes. I enjoy that. No, it's interesting what you say, actually, because I have noticed that I sort of deal more on the trust disputes side of things, but I have had more cases of this sort of scenario where an unmarried couple is falling out and then they are coming to say, that's my property. He promised me the property. It doesn't matter that it's in his name. And you're right. You have to construct these arguments that for equitable relief, basically. You have to appeal to the court and say, okay, we recognize we have no legal title. We've got nothing in writing, but we do have evidence that either there was an intention that I was supposed to be given some interest in this asset, or that there was a promise made to me and that I've acted to my detriment on the basis of that promise. But you have to have a lot of evidence there. The detriment has to be real. A lot of these people you have to turn away at the beginning because you just say it's not really there. We can try, we can make out the argument, but I wouldn't advise you to pursue it in the courts.
Yes, so you can bluff your way into some sort of settlement.
Hopefully. So you make the case as strongly as you can in the hope that whoever's on the other side, potentially is also feeling some level of guilt, because assuming that it's true, they know exactly what they've done. And that hopefully you can negotiate something for the client out of that. But they're very difficult cases because it's the same as a sort of divorce scenario in that a relationship has ended. They're going through some sort of bereavement, but they're also realizing that they had no status in that relationship at all.
Yeah.
And there's very little that they can do to sort of secure anything out of it.
Yes. And it's a lot of recognition from the courts, actually. I think a lot of support from the courts. So the judges create these extraordinary stories just to provide someone with something. It's high-risk litigation. It's very fact-specific, and it's also, to some extent, dependent on whether the judge likes you or doesn't like your ex. And if you've got children, it immediately becomes a lot easier. But if you've lived with someone for 30 years, and the house isn't in your name, you've got no rights, and then you have to construct some sort of story to give you something, which is a ridiculous way of legislating. Because
but as you say, the courts do tend to act what's the word I'm looking for? Justly. They do tend to act justly. If it does come in front of them, and there is a sense that someone has been trampled on and done over and promised the world and then just dropped, they will try and find a way through the case law, but which is why the downside of the courts having such a wide discretion is that you never have any idea. You can never guarantee to the client this will work. But you do tend to have a sense of whether or not it's something that most judges, most courts are going to have sympathy with and will look for a way through the quagmire of the various case authorities to provide you an outcome that at least gives you something. More often than not, you never get there. You never get in front of the judge.
The civil courts, because we're always told, and I think I can say it's true, the civil courts are much more black and white. Family courts are always wandering around looking for a sort of big-hearted solution, whereas the civil courts are more conservative.
Yes, I do think that's true. Absolutely, I think that's true. And it's why, if we're given the chance, where we're on a sort of a sticky wicket, as it were, we will try and bring it in front of a family judge or the family court, like with a 1975 Act claim, which is for another day. But there are circumstances in which you would always issue that in the family division, which you're allowed to do, which with many of the claims that I deal with is not an option. But you would issue there for exactly that reason. But it is true vis-a-vis the family courts. But I also feel that within the civil court system, these types of disputes are given more leeway than others. You know, completely. Some of my work also touches on sort of commercial disputes because, trusts and companies and shares, it all melts in together. But when it comes to these kind of scenarios where a relationship has broken down, a person has been bereft, as long as their story has truth in it, I think courts can see straight through someone trying it on. But truly wronged person, if they have the wherewithal and the funding to get themselves in front of a trial judge, and maybe this is just my sort of love of the judicial system, even after all these years, but I still think that they more often than not, they will find a way to help them, which is great, but
also actually makes a bit of a nonsense of the legal system.
Yes,
because you're fiddling about trying to find a, quotes, fair solution to something where, frankly, they've got no legitimate claim.
I know, I agree. But I agree. But that's what I like about our legal system. Well. that probably is the best part of it. Okay, so basically, non-married, no kids is super problematic.
Yes.
And you need to go out of your way to evidence any kind of rights in property held in your partner's name. Non-married with kids is slightly better.
Yes, definitely.
From a Schedule 1 application perspective, because you can achieve something for your children and benefit from it that way.
And if your partner was wealthy, then it can be quite a nice life. If you're still in the cohabiting relationship and your partner dies, then, of course, as you would say, at least you've got a potential claim under the Inheritance Act, which we can talk about in more detail.
Yeah.
But at least in death, you might be better off than if
it had all
just gone wrong.
That's true. And probably we will have a session on 75 Act claims separately. But it is correct that irrespective of the will of your partner who has just died, if they haven't left enough for you anyway, as long as you have been living up with them up to the point of their death for the last 2 years, then you have grounds to bring a claim against their estate. Although in that scenario, if you're still in a relationship with them, you would hope that their will might have provided for you.
Think of all the people who never make wills.
That's the point, isn't it? That if they haven't made a will, then on intestacy, if you're unmarried, you get nothing.
Yeah.
Not even a look in. Everything would go to your children.
Or
in
if
that
you haven't
respect.
got children, to his or her siblings or parents if
Parents.
they're still alive.
Yeah. No, that's exactly right. So yeah, I mean, there are, I suppose, then some rights that attach to being in a relationship, but it doesn't work in the same way as it does in a marriage where you build up sort of credit, don't you, over the years, the longer your
Yeah,
relationship is, the
yeah.
sort of the larger claim you have to the shared property. Um,
Whoever's name it's in, doesn't
Whoever's name
matter.
it's in.
Yeah.
Yeah. It's
So
interesting.
what should we say to this woman? I think, maybe just get on with it, marry him, and then see if that makes you feel less bored.
Wait a year and then and
Yeah,
then you will be
and
in the
then
best
you're,
position you have
yes,
been yet to
yes.
leave the relationship. There you go. It's slightly flippant advice, but
But
if
there's
you're
truth in it.
there's truth in it, and also
I have actually given that advice. I have done it to a client. I don't know whether they took the advice, but I mean, obviously, it was all caveated with.
yeah, yeah,
It's
there are options, aren't
there
there?
are options. Yes,
We're not suggesting that it's the only way to go, but it seems a sensible thing to consider.
partly because it is so bonkers that suddenly you get married, and I don't know how this developed actually. It wasn't always the case, but suddenly the years of pre-marriage cohabitation is just added on.
Mm, mm.
In fact, anyway, it's a different story. It's a case I advised on this year, which was very similar to that, which was very short marriage, very long period of cohabitation. Anyway,
And the effect was that you're in I mean, we can probably discuss this another time as well, but what is the great difference between a 2-year marriage and a 22-year marriage?
well, there's always a discretion, but broadly speaking, 2-year marriage, you've got 2 years where you divvy up everything equally. 22-year marriage, you've got 22 years worth where you divvy it up equally.
But basically, it's that if you're in a short marriage, you're only really looking at the assets that sort of accrued to you during that period. I mean, you look at it that you brought what you each brought into the marriage, and then it's only what accrued during
Yeah.
that period that gets divvied up. Okay.
And also, if you've got a long relationship and one person's earned a lot more than the other, either because of children or just because one's got a higher earning job, then the lesser earning spouse, wife or husband, can then make a claim for maintenance as well.
Interesting. I feel that we may be deviating into some of the topics that we will want to save for another week. So maybe we're going to end our chat and say thank you to everyone for listening. If you would like to send in a question that we can discuss, please send them to our email address, which is lawtorn@collierbristow.com. Bye.
Bye.